Okay. First order of business, I take it that you've noticed Justice Pickering is solemnly sitting in Las Vegas all by herself. And she couldn't be with us today. And so Justice Pickering, I appreciate you holding down the fort in Las Vegas. And I know we'll probably have some comments from down there as well. So thank you.
And I'm not all by myself. There are a number of distinguished members of the bar here present.
Oh, okay, very good. I was talking justice-wise. You have no colleagues down there. And I'll bet you miss us very much, don't you?
Yeah, totally.
All right, today is the time and place set for consideration of 80 KT number 495 in regards to the amendments to the rules of professional conduct, particularly 1.2. And this was founded by the State Bar of Nevada. Do we have a representative from the State Bar of Nevada here who would be present to speak?
Yes, Your Honor.
Yes.
May it please the Court.
I'm sorry. Before you get started, I just wanted to lay a few ground rules. We've received all of your information, all of the letters, the documents. We've read through those thoroughly, and so we're well versed in most of what you're going to present to us. So I'm going to ask that you limit your remarks to 3 minutes. And I would also ask that you not duplicate any of the comments made from previous speakers, and that'll make this go a little bit quicker, and we would all very much appreciate that. So if you'll keep that in mind.
Certainly, Your Honor. I'll take that as a license to be as brief as necessary under the circumstances.
Thank you.
May it please the Court. Justices, as you know, this amendment that we have proposed to Rule 8.4b, it's not actually an amendment to the rule, but it's a comment. And the language has been set forth in our pleadings as well as our justification for it. The Board of Governors took a long time considering this issue. Back in May of 2014, when you amended Rule 1.2d, the Court asked whether there were other rules that needed any sort of modification in light of that rule change. As you see from our pleadings, we analyzed 7 or 8 of the rules of professional responsibility and concluded that the only thing we would be recommending was this comment with respect to Rule 8.4b. We believe, based on having studied all the nuances of this issue and having had close to 7 or 8 hours of discussions amongst ourselves, despite the fact that we had a variety of viewpoints on how does medical marijuana fit in with the practice of law, that we do owe it to our members to have this comment so that it is perfectly clear where this issue stands with respect to the rules of professional conduct as they interact with federal law. It is indisputable that federal law still prohibits marijuana-related activity. And the Cole Memorandum has gotten this exaggerated importance in a lot of the comments, submissions, and briefing on this issue. And what we would ask the Court to keep in mind is that it really is nothing more than advice and prosecutorial guidelines with respect to how the federal government is going to be handling prosecution of marijuana-related crimes across the country and how that interacts with legal, under state law, medical marijuana programs. It is simply guidance, and as a result provides very little of a safe harbor for attorneys with respect to whether or not they will ever be prosecuted by the federal authorities for violations of the federal law, even though they're permitted to do what they're doing under state law. Certainly, they'll have an impact, but that could change tomorrow. And I have some experience with the creation of these kind of guidelines years ago when I was U.S. Attorney. We were all summoned, those with the HUD cases were summoned back to help develop HUD fraud guidelines. Well, those lasted about 6 months because it's an ever-changing universe with respect to the department's resources and what they can devote their resources to and what they choose to devote their resources to for political reasons, efficiency reasons, or whatever else. We have a presidential election coming up. You'll have a new deputy attorney general probably even before the election, given it's the end of a term. Reliance on these guidelines for purposes of definitively demarking what is ethical and what isn't would be a serious mistake in this case. Ergo, we focused on Supreme Court Rule 111 because all of our members should be advised, just as all of the clients of the individuals affected by Rule 1.2b are advised, that there are federal laws that come into play here and that this possibility does exist, that were they prosecuted under Rule 111, there is a procedure by which this court would be advised of that conviction, and they could, maybe not absolutely will, but may be subject to discipline at a later time.
And I'm going to ask my colleagues if you have questions, although I've limited the speakers to 3 minutes. I know there's going to be some questions and some comments. And as you know, the citizens of this state amended the Constitution to allow for medical marijuana. And so I believe, how many other jurisdictions? I think there's 23, probably more. It's growing every day. So what are there now? Do you know?
There are 23 that, well, actually, I think 24 for medical marijuana and just 2 jurisdictions in which it's recreational use.
And I know other jurisdictions are considering the same type of amendment as well. And so we're faced with this inherent conflict between the federal law and what our citizens have clearly demonstrated by amending the Constitution. And so we appreciate your input, and your primary focus is making sure that this is what I'm reading into what you just said, making sure that the attorneys don't run afoul and run the risk of being prosecuted, even though it's maybe legal on a state level by virtue of the Constitution. There's also the federal laws that come into play, and that's your primary concern.
It is, Your Honor, yes. We feel that we have had so much inquiry about, well, is it okay to be an owner in a medical marijuana business? Is it okay if I use medical marijuana privately for a medical condition? And the range of opinions on that is so broad when we talk to our constituents that it's hard to fashion a position that would say this is what the lawyers of Nevada think. But some things are incontrovertible. The federal mandate that it's illegal, the fact that we do have a regimen set up under the rules of discipline that could handle a situation if it were ultimately to result in a federal conviction. And then this set of guidelines out there, which under our ethical rules, lawyers could rely upon to an extent if faced with a disciplinary claim that, well, under the state circumstances and the law, I was acting within my ethical duties.
You also had mentioned the possibility of a change in the administration, new attorney general that may have differing views. Would it be more appropriate for us to wait and see what happens? Would it be more appropriate for us to wait until there's an actual issue with an attorney running afoul of what you think may be an ethical rule?
Well, Your Honor, when you do this, or if you do this, is totally within your control. The reason we crafted the comment the way we did is it's indisputably true and reflects the current state of the rules and the impact. I believe much of what I've seen in the way of commentary might be from others who want the rules to be broader or more detailed about this issue, might well wait to another time for consideration, either in an individual case or when the political landscape is different. There was some reference to the cultural change, I think, in one of the comments, and things like that are so hard to predict. And given the totally unpredictable political landscape now, I think getting too much into the weeds on exactly what marijuana conduct should be permissible and not Your Honor, you're right. It may be premature to do something like that, which is why we limited it to something we feel is universally going to be true no matter how those issues work out.
Okay, very good. Colleagues?
Mr. Parker, I'm a little bit unclear about the comment. So was it the intent of the Board of Governors' recommendation to simply alert attorneys that a federal prosecution for use or distribution of marijuana may trigger or may call into being disciplinary proceedings, or was it broader than that? I mean, I'm a little confused by your responses to the chief, because looking at the language, it would appear that what you're saying, at least the way I took it, is if there's a federal prosecution, that may lead to a disciplinary proceeding. Is that the intent?
Well, because we're referencing Supreme Court Rule 111, we were referencing a conviction, which certainly under that rule has to start that process where the conviction, this court is advised of the conviction and those proceedings begin. I think with the conduct short of the conviction, if that's the area that Your Honor is looking at,
Right.
We had no consensus about, or certainly no appetite of a majority vote to go to the extreme to say, oh, by the way, that conduct violates federal law and is a violation of your ethical duty. We don't agree on that, and I know you see from the commentary from others that that's a hotly disputed view of things. But it is, as a practical matter, if the Cole Memo stays in effect, then no one's going to get prosecuted by the federal government unless they have violated the Nevada Medical Marijuana Act and stepped outside of what that act permits and outside of those 8 principles that the federal government is watching very closely to make sure that these programs stay within. So what would happen under those circumstances is, and it's kind of the McIntosh case, you'll hear that from others, I'm sure, but I wouldn't, if I were representing one of those defendants, take much comfort from it in the sense that it deals with a funding issue which could change overnight, but also it deals with this whole issue of people defending federal cases based on their compliance with the state regimen. And if they step outside those Cole guidelines or Cole memorandum guidelines, then that's what would trigger the prosecution. So I think in a real world situation here, if we had someone who, for instance, was a medical marijuana licensed participant and an attorney, and for some reason they decided to grow marijuana on federal land, or they used firearms to guard their property from trespass, or one of those that might arguably violate a Cole principle, then I could see the Department of Justice saying, no, you're not doing medical marijuana. You're outside, you're in these areas that we are very concerned about under federal law, and we may bring charges against you.
Well, if I could, there are innumerable hypotheticals that may or may not result in a federal prosecution under these circumstances. I'm just trying to clarify the Board of Governors requested comment. And my understanding of it, it is extremely narrow. It is saying attorneys are advised that in engaging in conduct may result in federal prosecution, and that may trigger discipline proceedings under 111, which don't come about unless there is a conviction.
Yes, and that's the notice that.
So is there anything broader than that you're trying to convey?
That we are proposing as a comment?
Yeah.
No.
So it isn't it's not an instance where you're, you are objecting to use, possession, or distribution by an attorney. It's simply advising that such conduct may result in a prosecution.
That's a separate issue, Your Honor.
But not one we're addressing today as far as this ADKT is
This
concerned?
comment, no, because
Okay.
if there's a violation of federal law, then it's a violation of federal law. Nothing we say in a comment will change that.
Correct.
But for the purposes of our task after the last amendment to Rule 1.2 is look around and see if there's any other place it needs to be clearer or any rules that need to be changed. In this context, given the kind of questioning we discussed a broad range of considerations that ought to apply to this medical marijuana situation. We could all agree, or the vast majority of us agree, that should it come to this position where somebody were convicted of a federal crime, then yes, this would clearly
Address it then.
and lawyers would need to be aware that you can go out there and do this, but be aware this could ultimately end badly with you subject to discipline.
Colleagues, any other questions? How about Justice Pickering?
No questions of Mr. Parker. Thank you, Rick.
Okay, thank you very much for your presentation. You set the basis for the rest of our comments. And what I'll ask, Tracy, have you had everyone sign in that wished to speak?
I believe they have.
Okay.
And
All
I
right.
have sign-in sheets down here, Chief, as well.
Okay, thank you, Justice Pickering. I think what I'm going to do is take the speakers up here first and then switch down to you and then have your speakers participate if that's acceptable to you.
Yeah, I have one yes, possibly, and a probably.
Oh, okay, well, that's decisive. Anybody else here in Carson City that would like to offer some comments? Mr. Kennedy?
May it please the court, Dennis Kennedy. In my 3 minutes, I'd like to just make a couple of points to follow up on what Mr. Parker said. I'm speaking in favor of the adoption of the proposed comment. It's both necessary and appropriate now at this time. We're a self-regulating profession. The rules of professional conduct provide generally the structure of that regulation, and the comments to the rules of professional conduct explain and illustrate the rules. In this case, Rule 8.4 totally is a pretty general rule. 8.4b is a very general rule. And the illustrations of the acts that are typically found to result in discipline under 8.4b are found in the comments. I can tell you that what the court is considering now is not anything that's real unusual. Back maybe 15 years ago, there was a great concern with civility in the legal profession. Rule 8.4 doesn't cover anything about civility, and yet when you look at 8.4d, it talks about disruptive conduct. What the ABA Committee on Professional Responsibility did was they dealt with that problem by adopting Comment 3 to Rule 8.4, and this is roughly 15 years ago. And Comment 3 is the civility comment, and the ABA Committee on Professional Responsibility said, look, times have changed now, and we have an issue with civility. What we're going to do is we're going to adopt a comment that says disruptive behavior, comments about ethnicity, sex, et cetera, et cetera, et cetera. We are advising members of the profession by this comment that those are deemed to violate the rule. And that's what the comments to the rules do. They provide animation and illustration of the general principles that are found in the rule. And that's what this comment does. As Mr. Parker said, it takes some things that are indisputable. Number one, that cultivation, sale, and use of marijuana violates federal law. It's beyond dispute. Number two, it might result in a prosecution of you under federal law, also indisputable. And that may result in discipline under Rule 111, which is the convictions rule. And that's what this comment does. It doesn't deal with all the stuff in between about what lawyers may or may not do. It simply says to lawyers, because of the social behavioral issues that we're looking at now that we haven't seen before, we're going to adopt a comment that advises lawyers on certain things that may occur under the rule. And that's all this rule does. It's an appropriate thing to put into the comment, and it's also appropriate that this court adopt that comment to say to lawyers, this is the state of the disciplinary structure now.
Do you have the same position as Mr. Parker does with regard to the Cole memo and the guidance that may or may not be there?
Yeah, I think he's completely correct on that.
Okay.
That essentially we're not going to prosecute if you're complying with state law, but if you get outside of state law and do any of these things that we've put in the memo, or maybe other things as well, you can be prosecuted for that. Yeah, he's right in his comments on that.
And maybe if there's a change of administration, then the rule would have to be revisited as well as the comment.
That's right. The rules and the comments in particular are fluid and flexible, and they are there to adapt to social and behavioral changes that occur and that may be unforeseen. I go back to the comment 3 that was added to Rule 8.4. It's a perfect illustration of when things change. You can illustrate the rule by a comment, and that's what the bar is doing here.
So, Mr. Kennedy, let me ask you that. Were you done, Chief?
Oh, yes.
Let me ask you this. In essence, do you read the comment or proposed comment as narrowly as I suggested to Mr. Parker? That is to say, you may be the subject of federal prosecution, and if so, that may trigger discipline proceedings.
Under Rule 111.
Yeah.
Yeah, and that's the narrowing provision under Rule 111, because the predicate there is a conviction.
So here's my question. If it is undisputable that this conduct could lead to a federal prosecution or conviction, and if it is undisputable that such a conviction would lead to, or may lead to disciplinary proceedings, why do we need to tell the lawyers that? How does the comment provide guidance to the lawyers when essentially we'd be telling them something that they already know?
Well, Your Honor, I agree with what you just said. There's a lot of comments to the rules, and when you read them, you say that should be obvious to anyone. But it's my understanding that a number of questions have been raised with the bar and with the Board of Governors that call into question what conduct may be proper for attorneys, and that the Board of Governors has said, look, here's a comment that everyone can live with. I agree with you. People should know this, but it doesn't hurt anything to put it in as a comment for guidance for lawyers.
Right, but I think what's, at least from the various presentations, materials we've received, what the comment to me has generated is a lot of speculation on the other side that the comment does more than what the comment says. That it acts somehow as an admonition that you can't have an interest in one of these facilities. I don't read the comment to say anything of the kind.
It doesn't say that.
Or that somehow the comment invades somebody's constitutional right under the Nevada Constitution to engage in this activity. It doesn't say that either.
No.
But I guess what I'm trying to understand is, in effect, the comment is telling lawyers something that is apparently obvious. So what does it accomplish?
You're correct. What it does is it addresses an issue that maybe 5 years ago didn't exist, and lawyers have raised questions about it with the bar, and the bar has decided that this is an illustration of the reach and the impact of the rule that should be given. I agree with you. It should be obvious to everyone that this could happen. But then again, based on my experience in ethics and disciplinary matters,
No, that's true.
I've had a number of clients to whom things like this were not obvious at all.
Mr. Kennedy, Chief, could I ask a question?
Yes, go ahead, Mark.
Mr. Kennedy, thank you for being here, and certainly some of your stature and experience in ethics and judicially, we really appreciate the opportunity to hear from you and comment. I had this kind of question as I was digesting all this material. Again, it's a historical issue. In 1931, Nevada legalized gambling. It was the only state till 1975, 76 when New Jersey did it. It was illegal under federal law, yet I believe attorneys invested in casinos here from the 1930s on and owned interests in them, and something that was not ratified or approved by the federal government in doing so. I mean, I think theoretically you could have been prosecuted for gambling operations under federal law, even though it was legal within the state. But attorneys were allowed to own interest in casinos and do so to this day. Is that any type of an analogy in your mind to this situation with medical marijuana and the issue with the federal prohibition versus the allowed by state law?
No, only, and I think only in a broad and vague sense. Gambling was illegal, of course, under federal law, but certain states' rights were recognized. To my knowledge, no lawyer was ever prosecuted for that. I think it's a little different now dealing with controlled substances. There's an express federal prohibition on that, and the federal government actively prosecutes those cases today. And it's not a sort of a laissez-faire situation that we had back with gambling.
Okay, thank you.
Mr. Kennedy, I was glad that you came. We were together at the event that honored Sam Lionel and Orrin Mulaski, and I've known you actually since you started practicing law here. I'm a little older than you. And I wanted your opinion because I felt all sides should be presented in this. And I'm just going to ask you this question. Are you against ownership interest of medical marijuana enterprises by attorneys?
Personally, no. No, it just you assume that those lawyers understand the risks that are attendant to that.
What if this court decided that the rule would be that ownership interest in a medical marijuana enterprise is lawful and is not discouraged? How do you feel about that if we would make that ruling?
No, I'd be fine with that. I had a little problem with the gaming position, saying that gaming licensees can't have ownership interests. I don't think there's anything to prohibit or anything wrong with a lawyer having a legal interest in a legal business.
And I do respect your experience in ethics because I know you've been one of the better attorneys on that issue. So thank you for coming here today.
Justice Pickering, anything for Mr. Kennedy?
No, thank you, Chief.
All right. Thank you, Mr. Kennedy.
Thank you.
Appreciate your comments. Okay, what about anybody else here in Carson City? Mr. Gentile, Mr. Arascata?
Good afternoon. Simply stated, the whole purpose of the rules of professional conduct the state bar as it relates to those rules, and this court as it relates to overseeing the state bar, which is an arm of this court, is to, in this arena, do two things. Protect the public from dishonest, untrustworthy, and unfit lawyers, and to preserve the public's perception in the trustworthiness, honesty, and fitness of lawyers. You've said that over and over again. Every other court has too. This is not a federal issue. This is a Nevada issue. The federal issue here is the federal law, the illegality of conduct that is protected under the Nevada Constitution, mandated by it, mandated by the voters, and controlled by the legislature. What this court needs to do is not reiterate the rules that should be plain and clear to anybody who passed the bar who could read them. If you're prosecuted under the federal law, the rule does in fact say that Rule 111 could apply. What this court needs to do is to articulate a safe harbor, just as it has in First Amendment cases with the rule. That's what needs to happen here. Or nothing. Justice Hardesty, you're right. This rule doesn't do anything, doesn't add a thing. But what the public has said, because you guarantee yourself, and I know it, nobody who voted for the passage of an amendment to the Constitution, who believed that medical marijuana was a good thing and a necessary thing, considered themselves in voting for it dishonest, untrustworthy, or unfit. Nobody did that. They have spoken loudly that the culture of Nevada today, whatever it may once have been, the culture of Nevada today, and this is a cultural issue. Culture gives meaning to the public's perception of what's dishonest, what's untrustworthy, and what renders someone unfit. And they have said that it doesn't make them unfit, so why should anyone believe that the perception would be that it would make a lawyer unfit? If a lawyer is prosecuted for a federal offense that is protected by Nevada law, and that's the condition. In other words, it falls squarely within what is lawful in Nevada, but does not under federal law, then that lawyer ought to be given protection by the rules with respect to subsequent discipline. If he varies in any way, shape, or form from what is protected by Nevada law, that's another story. That's another story. He doesn't have the protection, or at least it becomes a factual issue that has to be hashed out in a disciplinary proceeding. And so I guess that's my 3 minutes. I think I've said what I need to say.
All right, and colleagues, do you have any questions?
Now, what's the safe harbor, Mr. Gentile, that you offer?
Personally, 8.6.
In looking at your, pardon me?
The rule that was proposed by the standing committee that apparently was not reported to the court for its consideration, which is 8.6. Yes,
Okay,
and what it should say is that if you're obeying Nevada law, you're running the risk of a federal prosecution, but we are not going to deem what you have done to render you in any way adversely reflect on your honesty, trustworthiness, or fitness to the practice of law.
So we should not adopt what the State Bar has proposed, as far as you're concerned, and adopt a real safe harbor that everybody in the world could understand that there is nothing wrong with a lawyer in the state of Nevada having an ownership interest in the medical marijuana enterprise.
Without reservation. That is absolutely.
If you're clear like that, I don't think anybody could mistake it.
No, I mean, what we don't have is that. What we do have is what they're proposing to give us again restated.
And you believe any other jurisdictions that have done that?
Yes, 2 of them, Colorado and Washington thus far. Okay. 2 different jurisdictions in Colorado.
Does Colorado allow lawyers to have interest in dispensaries?
Yes.
Wasn't sure.
There are actually 25 states that have adopted it by my count, but I could be wrong.
25?
And Guam and Puerto Rico.
So I was going to ask you, if the chief was done with his question, I was going to ask you or some other speaker to comment on the Ohio court's opinion.
It just came down, I read it, and the comment, the opinion itself basically says to the Supreme Court of Ohio that other states, and it names Nevada, have recognized this problem and have taken measures to modify the rules or supply a commentary. It says that in the text. I know you've read it. That is clear as a bell. I've named 7 states that have taken action, including us. And that's what sets us apart. Separate and apart from that, we have a constitutional mandate here. This is not a legislative enactment.
Mr. Gentile, just as an advocate in a different way, I understand the proposition that we would have state law and that protection. And since we've not had any federal prosecution in Nevada reference to this, where will we be once we had a federal prosecution, even with our state law?
Well, do you want my real opinion on that, or do you?
I'll take both.
Okay. My real opinion on that is good luck finding a jury that's going to convict somebody if they're within the 4 corners of what the people of Nevada mandated. Good luck. You better pick a real good case to bring your first prosecution, or there won't be a second one. All right. Now, that's my honest belief, and you all sat as trial judges, so you know what I'm talking about. All right. Now, separate and apart from that, I think if the federal government brings a prosecution, obviously they can pick their case. It's not a reactive situation. It's going to be a proactive one. And they, more likely than not, and by the way, I am speaking, everything I said assumes that Cole and Ogden are gone and Congress has said, have at it. Okay? Because I don't think you can count on any of that. All right? So we have to look at the worst case scenario. We have to look at what might be tomorrow, just like it was a couple of years ago. I cannot envision a federal prosecutor getting permission from the DOJ to bring a case that in fact called into question the protections that are supplied by Nevada. They're going to bring a far more egregious and easier to prove case. That's my opinion, and I've tried a couple of cases.
Thank you.
If we do affirm the State Bar's proposal, what do you think will happen as far as lawyers who transfer their interests to a spouse or a related third party or go inactive?
You know,
You think it'll
that's
cause
making them dishonest. You are forcing a lawyer to be dishonest or untrustworthy if he's got to pull a shenanigan like that just to avoid the possibility of a disciplinary action. That's not something this court wants to do.
You think it may cause that?
I'm sorry?
You think that it may cause that if we adopt
I do.
this?
I absolutely do think that. And to what end?
See, and I don't read the proposal that narrowly. It doesn't prohibit anything.
No, it doesn't.
It essentially indicates just be aware. And I don't see why that would cause a lawyer to transfer an interest to a spouse or anybody else.
It's a cold feet response is what it is. That would cause it. Okay, an abundance of caution, perhaps, would be another way to say it. I agree with you. Yeah. This rule doesn't say anything that's not already there. It certainly doesn't say what you just said it doesn't say. It doesn't say that at all, okay? But it also doesn't provide that level of comfort and protection that is necessary. Look, if we are going to move forward for the people of this state, then there ought to be at least a pronouncement from this court, as there was with respect to Rule 1.2, that there is a safe haven, that there is a safe harbor. Not just for lawyers. I mean, obviously, when you're dealing with the rules of professional responsibility, they only apply to lawyers. Okay, but there's got to be a nexus between the conduct that's causing discipline and something that reflects dishonesty and untrustworthiness. Every state that has taken that up has said there is none.
Do you know if in the 25 states and the other properties that have lawyers with medical marijuana. Have there been any notable federal prosecutions in those states
I haven't found
with
one.
lawyers involved in?
I haven't found one that involved a lawyer. I haven't found one. It doesn't mean there won't ever be one, but again, I have to say that with the amount of discretion that is afforded a federal prosecutor and what you know will be DOJ oversight. Chris Christie said that if he gets to be Attorney General, the first thing he's going to do is bring a case like this. Didn't he say that? Although at the time he was running for president. You know, that could happen, but I just don't see them bringing a case that would fall within the protection of the Nevada statute. It'd be foolish on their part. It'd be like bringing a porn case, okay? The minute the jury started quitting on porn cases, they stopped bringing porn prosecutions. You're going to run into the same situation here.
Colleagues, anything else? Justice Pickering?
No, thank you.
All right,
Thank
thank you,
you very
Mr.
much.
Gentile. Mr. Arascata, have you got anything to say, or?
I think you used all my time.
Okay, use your time. Okay.
Go ahead, if you'd like.
If you've got something else to add, in addition to what's already been indicated, feel free to come up.
I believe it's been stated. I just want to touch on what Justice Hardesty has asked multiple times of other speakers. And I think really the question he's asking is, you know, why is this comment even being brought forth? What it really is saying is, if you violate the law, you could be prosecuted by the state bar. You could face disciplinary proceedings. And that does not add to the rules of professional conduct whatsoever. That's something, as Mr. Gentile said, anyone that's passed the bar knows you have to follow the law. And it's almost as if the federal government, outlawed Kool-Aid. And the state of Nevada says, no, Kool-Aid is lawful. And then we're in this position where the state bar comes out and says, don't drink the Kool-Aid. And right now what we have is a situation where that the bar wants this court to drink the Kool-Aid, so to speak, and put forth a comment that there has to be other basis or purpose or reason for it to be there, that which I do not know, for the bar, because it's just asking us or telling us as lawyers, if you break the law, you could face disciplinary proceedings. And I just want to add that comment briefly.
So is it your position that this comment essentially we shouldn't do any comment?
Absolutely correct. And if anything, add the safe harbor that Mr. Gentile mentioned to Justice Cherry, because it does not add anything.
You don't want to go as far as I've gone, though, to say that it's absolutely legal for a lawyer to participate in medical marijuana enterprise, so that the people in the public understand why any lawyer is involved in a dispensary or a plant or whatever.
I agree and think that would be proper, but I think I'd be disingenuous if I then said, I agree with you and that should be the rule when I'm arguing against the rule being placed in. But yes, I think that would be more proper.
Mr. Arascata, I appreciate what you said today, and I don't really take issue. I do take issue with the comment, though, of unnecessary, because probably for the last 2 or 3 months, as you pick up the Nevada Journal, we have 2 or 3 pages of attorney misconduct. And we think attorneys of all people should know the rules. That's a bad assumption, because they keep breaking them. And some very talented, very educated people do that. And then they look at us, I didn't know it was a mistake. It's an inherent problem that's always going to be with us, I guess. Wouldn't it be safer just to make sure one more time we've said it, that, you know, you may be subject to this, so when they want to look at us and tell us, gee, I didn't know?
I agree. However, you stated they don't know the rules. Our rules of professional conduct are there and to be read. If you're saying people are coming forth, attorneys being disciplined and saying, I didn't know that was the law. Well, that's shame on them, because the law is for everyone, not just attorneys.
and they come in and they come before us and they make the argument, we really didn't know, you shouldn't slap us on the hand, you shouldn't beat us up, you should allow us to go forward, and they come back a second or third time. We're dealing with fragile egos and personalities. So I think if we say it and we say it often enough, maybe we'll have fewer people that make those kind of mistakes and get themselves in trouble.
I appreciate what you're saying, Justice. However, we already, as I said, have done that. And if you're going to say just follow the laws so everyone knows, then drop a footnote and say, see the United States Code annotated and also see the Nevada revised statutes. Because if it is directed to follow the laws, just because we have this situation with medical marijuana and marijuana has been illegal and has created a huge national discussion, the issue still remains the same. The people of the state of Nevada have passed the constitutional amendment, and we do have this federal state pull. However, what the comment can say is just that. It's focused solely on the medical marijuana industry. I believe if you had what Justice Cherry said, that the being involved in the industry is not a violation of law, and I'm summarizing that, fits perfectly in, but just to focus on one law because it has been part of our national discussion, everyone, as attorneys, it's incumbent upon us to know the law and not to violate it and not come forth and then say, I did not know. And that's why I suggest if we're going to do this, instead of focusing solely on medical marijuana, drop a footnote and say, see the United States Code annotated and see the Nevada revised statutes regarding all laws.
Okay, Justice Pickering, anything for Mr. Arascata?
No, thank you.
Okay, thank you, Mr. Harris.
Thank you for the time.
Okay, any other speakers in Carson City would like to come up? All right, seeing no hands, I'm going to switch down south to Justice Pickering and ask if you've got any speakers there that would like to make a presentation.
We do. I think we have 3, and perhaps more others have come in as this hearing's been underway. So if anyone is interested, would they please come forward? And for the record, state your name first. Thank you.
My name's Tom Haney.
Thank you.
Give me a second here. I usually don't do this. I play third base.
Can you hear him all right in Carson City, Chief?
Yes, thank you.
Hi, Justice. My name's Tom Haney. I'm a 50-year resident here. I grew up right up the street. John Lobb and I started the Las Vegas Medical Marijuana Association approximately 36 months ago. Like most of us in here, all of us know about a 2- and 4-finger bag from the 70s. It's all changed. So I'm no hypocrite. I'm not a card holder. I didn't inhale and have sex with that woman. So lawyers should not be allowed to be part of the medical marijuana industry. Las Vegas Medical Marijuana Association started 34 months ago. John and I. There was an information and dissemination of vetting many of the safety packaging, branding, dosage, kid-proof exit packaging, health and human services, point-of-sale systems, security systems, RFID tracking systems, breeders, cultivators, banking, insurance, lab, test equipment from around the country. I brought them in. I also brought in the largest amount of edibles that you'll see in the state that's being manufactured for 2.5 years later through CW Nevada. That is one of the issues with the attorneys here today. The LVMMA being a platform of all sectors of this industry, we hope weekly events disseminate information, connect, advocate. References to the justices are on page 20, 21, and 22.
Of your spiral presentation?
I'm sorry?
Of your presentation?
Yes. There's, in page 20, you'll see about 115 products I had 2.5 years ago before anyone had a license in this room that might be an attorney. And I believe there's some great attorneys in here. I believe we have a few bad apples, as one of the justices mentioned, that were disciplined. 3 of them I heard him say. Look closely at the table. There's 115 products there. Three of those companies, there's more than that there as far as, I didn't have the banners, but those are my banners. That's my business, Las Vegas Dispensary Solutions. All those products there, as of last week and this week, the next 2 or 3 months, they'll be mixing up the first batches because we can't send them across state lines. I had those products here uninfused 2.5 years ago before anyone in this room had a license. Safety packaging, branding, dosage for our tourists and for the public. It's public safety. That goes for medicine. That goes for recreation, either one. We have a long way to go. We're moving way too fast. Way too fast. Page 21, there's our tent at one of our barbecues. I'm a founder of the LVMMA, John and I, lifelong friends for 50 years. I'm the owner of Las Vegas Dispensary Solutions. I'm the sole owner. Page 22 is our public safety program I tried to get going a year ago. That's straight out of Colorado. Colorado has, let's say, a lot of learning to do themselves. They're only about 2 years old. We're less than that. Some of the places are still opening. I think we have 40 open as of this week in our newsletter that we put out for the LVMMA. I think we just hit about 40.
All right, thank you, Mr. Haney. Our colleagues, are any questions for him?
I have a lot more here. So.
No, we're limited to 3 minutes, unless we have questions for you.
Chief, just for a moment. The clock is not on down in Las Vegas, so he did not have the warning light go on. Sir, the chief has put a 3-minute limit on speaking, and the sound rang in Carson City. I don't know if you heard it. But that's what he is relating to you, is that the 3 minutes is up, and that's what he's allotted. Normally, you would see a red light go on the podium, but because the main hearing is in Carson City, it didn't go on for you here. He's not interrupting you. These were the rules that he established.
Yes, and I assumed you did have that light down there, but of course, if my colleagues have any questions for you, we'll offer you more time. Colleagues?
I guess just one specific question. Historical viewpoint of what's going on is interesting and illustrative. What is your position as to the issue before the court? Reference the court having some comment about the rules of professional conduct for attorneys.
I called a few. Judge, Your Honor, I called a few of the attorneys. Some of them are personal friends. I've been here a long time. And I tried, you spoke of self-regulation. I believe in it, just like the gaming we had here. I've been here all my life. I tried to get them self-regulate. I know who made phone calls and who tried to straighten somebody out. You see their name right there. They are a couple, by the way. They're on page, smoking guns right here on page 6. Nope. On page 5, that is a couple. Both are attorneys. One, I have a contract with. I'm a client. I'm a vendor. I'm a supplier of the largest operation in the state almost with edibles. They will literally have the largest operations. 20,000 square feet today, 40,000 square feet. It's going through a full operation probably in 2 years. At that particular point on page 5, as you see that person there, they are a couple. She is an attorney. She's one of the top lobbyists in the state. If they're not what I call collusion in regards to the insurers, Aflac, American Council of Life, Hometown Health, because they handle CW Nevada, which is Charlotte's Web. Okay? That is well known in Colorado. The Stanley brothers are doing fine with it. We don't grow it well here because they ended up with pesticides and mold in their grow. They're sitting on 3,000 pounds that they can't sell.
I think Justice Douglas was asking you to focus on why lawyers, as a matter of professional conduct, should not be involved in marijuana dispensaries.
Be involved.
That's from 2015, February of 2015, I believe. This is when the lobbyists were up there. This is an attorney, a lobbyist, and they're talking about these laws here. I have the attorneys making the laws. She's an owner of CW Nevada, 15%. I believe John Ralston, and I also believe Las Vegas Sun. When they say things, and I look at the Secretary of State, nobody's even taking care of the Secretary of State because Paul Robarts, which is a personal grew up in the neighborhood right up the street. He hasn't been an owner for 2 years.
Okay.
They don't mention Ms. Laskovich here, okay? It's stacking the deck against, I'm sorry, guys. That's just what we have.
Does that answer your question, Justice Douglas?
Not really.
It doesn't answer mine.
Regulated by the attorneys.
Is he in favor or against?
No. I think that your time is up, but I was asking Justice Douglas if he had a follow-up question.
The easy question is, are you for or against attorneys being involved in this industry?
I'm against today the attorneys because of the problem I see here, but I think we're moving too fast. I have nothing against recreational. I have nothing against. I just happen to run into a bad apple, Judge.
Thank you. Yeah, thank you
Okay,
for coming.
colleagues, any other questions? All right, thank you, sir, and we'll move on. Justice Pickering, anybody else there in Las Vegas?
I think we may have several more. Does anyone else want to offer comments? Mr. Bernstein.
Thank you, Justice Pickering. Ed Bernstein. And thank you, Justices, for allowing me to speak. I'm speaking as an investor, and I'm just reflecting backward on the amount of background information and regulatory information how to provide in order to get licensed as a dispensary owner. It was equivalent, if not greater, to what we're all accustomed to in gaming licenses. The scrutiny that we went through in getting a license was second to no other industry, I believe, in Nevada. And having gone through that, we ended up with attorneys who I think you want as investors in dispensaries. My partners are, one's a doctor, Florence Jameson, another is an attorney, Ross Goodman. Now, these are the credentials of people that you want following and carrying out the regulatory scheme in Nevada for medical marijuana. And I don't think we're moving too fast. In fact, we're moving quite slow. This was approved constitutionally in the year 2000. It's been over 16 years now that we have finally gotten here. And as you noted, what's going on around the country is indicative of where this country is going. We talked earlier about what may happen in an election. Well, we have an election here in Nevada, which would be very curious to see how the citizens in Nevada vote. Additionally, it's my understanding that both presidential candidates have been supportive of, at a minimum, the current law and even enhancing that law. But finally, I'd like to just remind the court that unlike gaming or prostitution and other activities in Nevada that we allow that other states don't, this medical marijuana bill has a compelling public interest. This helps sick people. I have a personal story. Many of the justices on the court know my personal story, know my daughter, who is a medical marijuana patient, and it has helped enhance her life dramatically. So we're not here talking about gaming or prostitution. We're talking about medicine, and we shouldn't lose track of that. And by putting this comment in, you are discouraging attorneys from getting into the business when you should be encouraging. As Dominic has indicated, we should be encouraging the type of people that we want to be licensed in the state. And if an attorney investor or any investor in a medical marijuana business violates any provision of the regulatory scheme, there's provisions already built in Nevada law where you can lose your license, be suspended, and if this arises to a criminal act, as Justice Hardesty indicated earlier, you can be prosecuted by this court anyway on disciplinary issues. So, anybody has any questions?
So your point is the comment is unnecessary.
The comment is not only necessary, but I agree in the safe harbor. We should be encouraging lawyers to do this.
Mr. Bernstein, when you first invested in the medical marijuana enterprise, did you have any idea that you'd be facing this problem after your investment has been made and you've been in business for a while?
It's an excellent point, Justice Cherry. Not only did I not have an idea, but I relied on the call on the call rule, and I relied on what this court had said previously, and I relied on the NRS statutes, and a lot of us, all of us, have made significant investments based upon what we believe to be the status of the law.
Colleagues?
Questions?
Justice Pickering, anything else?
I do. If that's the case, and I'm not suggesting my views on this, but your point is in part that this comment is unnecessary because it states that what the rule already says, which is you are at risk of federal prosecution, and if federal prosecution ensues, that could put your bar license at risk. So if that's the case and it's simply extra verbiage in a comment that's unnecessary and sort of prejudging what might come up, then how could there be a reliance if the rule already said that? Do you follow my question?
Yes. I mean, it's redundant. What I don't like about this is that it carves out an exception for medical marijuana where it doesn't carve out exceptions for other offenses. So
federal treason, for example, if I commit federal treason, I'm at risk for federal prosecution and I may lose my bar license, but we're not calling out federal treason.
Right, and these look, you can have an unlimited number of these kind of carve-outs, but none of these other carve-outs serve a legitimate public compelling interest in providing medicine for our citizens.
Okay, I understand. Okay. Thank you.
You know, it's a shame the bar didn't take an active role in homeowners associations and their activities. We'd have a few less lawyers in prison. Just my thought.
Thank you.
I'm not sure whether there's anyone else in Carson who has questions.
I'm sorry.
Does anyone in Carson City have any questions?
Anybody else here in Carson City? All right, and I take it there's no one else in Las Vegas, Justice Pickering?
I think Bruce Gale is here and wishes to speak.
Oh, okay.
Please state your name.
Bruce Gale, bar number 3413.
Thank you.
Thank you, Justice Pickering, Chief Justice Paragari, and other members of the Supreme Court of Nevada. First of all, I want to disclose that I have ownership interest in two LLCs that have, one LLC has 2 cultivation licenses and 2 production licenses, and another LLC has 1 cultivation, 1 production license. I want to be hopefully very brief. I want to raise an issue that I don't know if it's been raised before, and it's the separation of powers doctrine. I was involved in the case, and I'll cite it to you. It's Berkson versus LaPalme, 126 Nevada Advanced Opinion 46. I won't go into lurid details about it, but it talks about the separation of powers doctrine. And there was an underlying case in Ray State of Miller, which was an undue influence case that Kerry Payne and I were involved in, and this Berkson versus LaPalme case arose out of it. So, with that being said, I'm not going to go into details of what that case says, but I raise the separation of powers doctrine because the prior revision to the Nevada Rules of Professional Conduct in 2014, the comment, gave the lawyers a safe harbor. And now this proposed revision, which I got to tell you, I haven't read since July, but when I first read it, I read it much broader than any conduct that the lawyer was involved in advising clients, would subject them to discipline. But, I guess it really pertains to ownership. So I want to go back to Article 4, Section 38 of the Nevada Constitution. Aren't you indirectly infringing on the constitutional rights of every citizen of the state of Nevada who has a right to obtain a medical marijuana card under Article 4, Section 38 by chilling that conduct of lawyers who have been an integral part in this application process? Aren't you really indirectly affecting the medical marijuana establishments and the constitutional rights of the cardholders? I will tell you, I was involved in the application process, and the 29 years of being a lawyer and 7 years being an accountant, certified public accountant before that, this was the most difficult thing I've ever done. the application process. And we have made a lot of steps forward. And I think if this proposed revision is adopted, it's going to have a chilling effect. I'm in favor of the proposed the safe harbor provision that y'all are advocating, but I'm not going to go into the history of medical marijuana. And there was comments, I think it was originally by, I don't know which justice it was, about, I think it was Justice Hardesty, about the state of the political scene right now. We have Tuesday, November 8th, question 2 is going to be on the ballot. Every medical marijuana establishment now, losing money or lucky breaking even, you're going to have a chilling effect on the potential. Thank you very much.
I think you may finish your thought.
Finish your thought, please.
Wrap up.
Okay. So the current medical marijuana establishments have been struggling, have had a difficult time enough. And I don't think any applicant who applied and or received a medical marijuana establishment would say they really needed a lawyer. They really needed more than one lawyer. Some people did themselves, but you know, the tides are changing. We have question 2 on the ballot, and recreational use. And I think I mentioned this before to y'all in another oral argument. Associate Supreme Court Justice Oliver Wendell Holmes said in his book, The Path of the Common Law, the path of the common law has been, it's not been logic, it has been experience. Experience has told us that prohibition of intoxicating liquors was a failure from 1919 to 1933. Nixon's war on drugs, declared in June 71, has been an epic failure. President Bush's, I think Reagan and Bush's escalation of the war on drugs has been an epic failure. We've made progress. It took the legislature from 2001 to 2013 to make the major significant revisions to the medical marijuana, to NRS Chapter 453A.
Okay.
You're cutting me off. Thank you so much.
Well, no, you may answer questions. I'm just saying you're past your time.
Okay.
But,
All right, and with that, colleagues in Carson City, do you have any questions for Mr. Gale? None? Justice Pickering, any questions from you?
I have none, but thank you very much.
All right, thank you, Mr. Gale. We appreciate your comments. Justice Pickering, is there anybody else there in Las Vegas who would like to make a
Someone
comment?
is rising to speak.
Okay.
State your name.
Good morning, Rhianna Durrett. I'm here on behalf of the Nevada Dispensary Association.
Thank
I filed a brief, and I just wanted to mention a couple of things that already came up, but I do support Mr. Gentile and Mr. Arascata's comments, and just want to point out that there was a comment that the state bar has received questions on this, and that's what prompted the comment. There's only several dozen attorneys that have ownership in medical marijuana facilities, so I think the state bar can handle those questions. I don't think that's an overwhelming amount of questions, and I appreciate that they do have state bar counsel available to answer questions. I oppose the comment because if it is added to the ethical rules, it will be confusing. Everyone is saying that it's clear, and so that, and if it is clear and then it's added and it's already there, it will be confusing because people will look at it and say, well, how is this different than what's already in it? And they'll have to figure out an interpretation that makes it different than what is already in the rules. I think it's actually confusing, and so if it is enacted, it should be clarified to say that that if a federal conviction occurs, it may trigger disciplinary proceedings if those proceedings, if the conduct reflected dishonesty, untrustworthiness, or unfitness to practice. And then you would have a redundant statement. So it should just be, I encourage the court to pass on the comment. Thank you. I'm available for questions.
All right, colleagues, any questions here in Carson City? No? Justice?
Quick question. In your brief, you mentioned possibility of us delaying any type of decision until after the election. Do you still feel that way, or should we work on this as soon as we can?
Yes, I think the court should continue this out. I don't think I specifically said the election. I think it should wait until after the election, but it should also wait for several congressional matters. There's a bill that Paul Ryan said he supports that would allow CBD oil to be used. So that just changes the medical marijuana landscape on the federal level, and other bills continue to go forward on the federal level. So we would have to continue to adapt our rules of professional conduct as the feds change their rules. And this is Nevada. We do things our way. We decide what's ethical within our state. And so I would encourage the court to, if it's going to go forward, delay that to see how several bills in Congress play out.
Okay, thank you. Justice Pickering, do you have any questions down there in Las Vegas?
No, I do not. Thank you very much.
I have a question.
Justice Hardesty has a question here.
Justice Hardesty.
Mr. Ed, can you hear me?
Yes.
Have I correctly pronounced your name?
Yes, thank you.
I guess I'm surprised that your brief does not urge the court to consider some sort of safe harbor rule. Why didn't you do that?
I think the issue should be left alone, but if the court is inclined to address it, I would like the court to, like I said, clarify. You are an attorney is subject to disciplinary proceedings if they receive a federal conviction, if it reflects dishonesty, untrustworthiness, and unfitness, because that is what the state bar is regulating. We're not concerned with every violation of a federal law. We're here to make sure that attorneys are behaving ethically. So I do think that if the court is going to address it, that they need to clarify that that's what this comment is saying.
I must say I find it interesting that the bar urges us to adopt a rule which everybody seems to acknowledge states what already is the case. And we are in an environment in which lawyers are operating with absolute uncertainty about their professional licenses and their financial future.
Your Honor, may I add something? If I had seen the brief submitted by Mr. Gentile and Mr. Arifata, I would have adopted their idea and put it in my brief. But I hadn't read theirs until after I submitted mine. So I do think the safe harbor idea is a good idea.
All right. Any further questions in Carson City? And Justice Pickering, you have no further questions?
No, none.
All right, Mr. Ed, thank you very much. What about additional speakers down there in Southern Nevada?
Is there anyone else who wants to be heard? It doesn't look as if there is.
Okay, and here in Carson City, nobody else? Okay, Larry, Mr. Jajesti, come on up.
Thank you for the opportunity. First of all, let me say that my comments here this afternoon are going to be made as an attorney licensed in this state, having been admitted 40 years ago, bar license number 88. My comments are not being made in my capacity as the immediate past president of the State Bar of Nevada. The State Bar's position, I think, has been adequately stated by Mr. Parker and the ADKT. As an attorney, my own personal opinion is that we regulate ourselves as lawyers. As an attorney, we take an oath before this court before we are allowed to be admitted and practice law in the state of Nevada. The oath that we take is one where we swear that we will uphold and follow the law. Those of us in attendance in Hawaii at the annual convention reaffirmed that oath as it was administered
by Chief Justice Peregrine. We take the oath for a reason. I like to think it has some meaning. I would like to think it has some significance. If it means nothing, and it's just some words that we mumble as we raise our right hand and swear to follow the law, if it means nothing, then why administer the oath? I have nothing against medical marijuana. That's not what this discussion is about. This discussion, in my opinion, is very simple. Should licensed lawyers in the state of Nevada, who have taken the same oath that we all took to uphold and follow the law, be allowed to have a financial interest in a medical marijuana operation? That is about as simple as it gets. And in my simple way of thinking, the answer to that is either yes or no. The Gaming Control Board in this state made it very clear some time ago, you want to apply for a gaming license, you shall not have an ownership interest in a marijuana grow operation. Why should it be any different for a body such as ours, where we are concerned about maintaining the public integrity in our profession, swearing to uphold and follow the law, and now all of a sudden find ourselves perhaps carving out an exception for our very own by saying it's okay for lawyers to violate the law. The law is violated when the act is committed. The law is not violated when the prosecution ensues. We have to remember that. That oath means something. And we have to have a bright line rule, I believe, in my opinion, again, as an attorney, that it's either permissible or it's not. Because we've heard today from certain individuals who apparently have invested a certain amount of time and money in going through the application process. And we owe it to all of our members that you can either engage in this kind of conduct or you cannot. I, for one, do not believe that disciplinary issues of the State Bar of Nevada should be turned over to a third person or a third party entity such as the federal government, and have the federal government tell us, the State Bar of Nevada, when and if we should discipline our lawyers. That's our job. We've been working at that real hard for the last couple of years, as the court is well aware. So that's my opinion. It's either going to be allowed or it's not. And if this court thinks it's appropriate for lawyers to have a financial interest in a marijuana grow operation, they just come out and say it. If this court feels that it's not appropriate because it violates federal law, regardless if you're prosecuted or not, the violation occurs when the law is broken, then tell us that as well. We owe it to our membership, we owe it to the public, and quite frankly, I think we owe it to the State Bar of Nevada as well, because now what do we do as a State Bar with respect to attorney discipline? We sit back, wait for somebody else to decide whether or not we should discipline. I don't know. I don't think that's a good idea. I don't think it's good policy, and I don't think it's good procedure.
Mr. Digesti, I have one question for you. In the jurisdictions that do allow use of medical marijuana, are you aware of any state bars who have adopted rules that are so specific that say yes or no, you can participate?
Chief Justice, I'll answer the question, but again, please understand that the information that I'm ready to impart, I received a number of years ago, and I received it not as president of the State Bar. I think I was president-elect that year. And so I don't mind answering the question. I just hope we can put it in some proper context, because I don't want to give any of you the wrong impression on why I'm here today. I wasn't even going to get up and speak, but after a while you sit and listen to this stuff, and I just felt compelled to make my point of view known. So with that said, I have different information than Mr. Gentile had with respect to the state of Colorado. I happened to speak to the state bar president, Colorado, I think it was a year or two ago at the Western States Conference. And Colorado, as we all know, is at the forefront of not only the medical marijuana, but also the recreational use of marijuana, which is permitted there. And I was very curious because I went up and I had a private session with the president of the State Bar of Colorado, and I asked him how their law impacted attorneys and whether or not attorneys could have a vested interest in a marijuana grow operation, and he said absolutely not. And I've seen documentation and commentary on that. Now, if they've changed their views since then, and maybe Mr. Gentile has more current information than I have, then I'll step back. That's the information that I was given. And I was also told, in addition, in Colorado, that if you're an attorney and you carry a medical marijuana card, you are still in violation of the rules of professional conduct in the state of Colorado. So I found that very interesting. A state so-called progressive in nature, at the forefront of medical marijuana legalization as well as the recreational use of marijuana, still found it necessary not to allow attorneys to have a financial interest in the grow operation. And again, I say, Chief Justice, that's the information that I received, albeit a year or two ago. If it's changed, then it's changed. But that's the best that I can offer up. And I'm not sure what's going on in the state of Washington. They're doing a lot of different things up there, as we all know, and that's fine. But I think the important thing is, what do we do here? How are we going to proceed, and how are we going to govern our own? We're going to allow it or we're not. And to my simple way of thinking, it's that simple. I don't think we need any safe harbor provisions. I don't think we need to get too fancy in the commentary. I just think we need a bright line rule. It's either allowed or it's not.
Thank you. Colleagues, any
I have
questions?
a question.
Justice Pickering has a question for you.
Thank you, Mr. Digesti, for your comments. I have a simple question, which is, do you support the addition of comment 8.4, or do you think it is too complicated and not helpful?
Justice Pickering, when I came today, I did not intend to speak. I will simply defer. I do not want.
Certainly, I appreciate the question's a bit awkward, and because it seems to me, hearing what you're saying, you would prefer something more declarative and simple that simply states either yay or nay on this.
As a lawyer and a dues-paying member of the State Bar in Nevada with license number 88, that's exactly what I would like to see.
Thank you.
Any other questions?
Mr. Jesse, I agree with you 100%. There should be a bright line rule. And why we would not want to do a bright line rule when such stakes are involved, I can't understand. I'm in favor of allowing attorneys to have a financial interest in, ownership interest in medical marijuana enterprises. And I think that you're the opposite, but both of us agree that there should be a bright line rule and that we should not dodge the question. And also it should be a bright line rule so that the public understands that it's okay that somebody like Ed Bernstein or Bruce Gale or anybody else is not breaking the law by being involved in medical marijuana enterprise. And I just think that it's our obligation on myself and my colleagues to do a bright line rule. If I'm in the minority, I'm in the minority. If I'm in the majority, that's okay too. I'm used to both. Although I'm used to the minority more than the majority. So let's see what happens. But I agree with you, Larry, 100% that we were beating around the bush. And the other thing I'd say is when the issue came up about lawyers advising advising people about medical marijuana enterprises. As a former criminal lawyer, I just thought about, gee whiz, conspiracy. This could be a conspiracy if it turns out to be some kind of fraud on the state as to the medical marijuana enterprise. I think Rick Packer would understand that certainly that lawyer could be indicted too, and then we could get into RICO, and you'd have to hire somebody like Dominic Gentile to protect you, and it could be an absolute mess. So bright line, Larry, I agree with you 200%. That's it.
Anything further?
Chief, I just had one question really directed to the court and you as chief. The information Mr. Jesse supplied was what I think we were advised at the Nevada District Judges Association meeting last spring about other state. I think the speaker told us he was not aware of any other states that had permitted the lawyers to own an interest in medical marijuana businesses. Mr. Gentile said he believes, I think he said Colorado and Washington allow it. Perhaps with your permission, I know we're concluding the public hearing, but could we get a supplement from the State Bar and Mr. Gentile or anybody else is interested? If the rule's been adopted, I'm interested in who's adopted it and what the rule says.
Well, in fact, and Mr. Jesse, thank you very much for your comments. I think we're done with those comments. Mr. Gentile and Mr. Ariscotta, if you in fact have anything with you that supports. You jumped up real quick, so I knew you were prepared a while ago.
We filed it. It's in our brief at page 14.
Right. But if you would put it on the record and...
okay. Is the brief not a part of the record?
It is. It's filed. Okay. It's part of the ADK. But for the
April 23rd, 2012, Colorado Bar Association adopted Formal Opinion 124. It then amended it December 10th of 2012. So that's the source of my reference to Colorado. There's also the Kings County Ethics Advisory Opinion, which came out of Colorado. That was October 4th, 2013. It is Advisory Opinion I-502.
Mr. Gentile, is Kings County Washington or Colorado? Kings County is Seattle. Is that what you're?
No, I know that Kings County is in Seattle, but my brief says Colorado, and I believe there is a Kings County in Colorado as well. So, yeah, because it related to RPC 8.4B in Colorado.
Okay. There's a Las Vegas in New Mexico too.
Yes, there is. And then the Washington State Bar Association Committee on Professional Ethics Advisory Opinion 201-501, which was passed last year, 2015. So the references that I made on the record, that is the backup for it.
Okay, thank you very much.
And some of them deal with distribution. Some of them deal with cultivation and distribution, as well as possession and use.
Okay, thank you. Again, any other questions? Any other comments? Just Pickering, anyone else down there?
There's a person in the audience has his hand up. Did you wish to comment again, sir? You need to come forward. He spoke earlier, so Chief, you may want to state what the time limits are on it.
Yeah, I'm going to give you 2 minutes if you've got a rebuttal to something that's already been stated.
I can add to those statements. We all can Google literally Supreme Court, marijuana attorneys, and you will see every state this is happening right now. Ohio tabled the attorneys owning these. They tabled it. So Arizona, just today, before I got here, attorneys are not allowed to represent MMEs today. I am very hip to what's going on. And the laws, the attorneys need to police their own. I can't make that any more clear. There's some bad apples out there. Thank you.
Okay, very good. Thank you very much. Any other comments, north or south? Okay, then we are going to adjourn this ADKT hearing. We are going. I don't know that it's necessary. Are any of the justices interested in supplemental briefing by any of the speakers or any of the parties that.
I support extending the comment period by 15 days, Chief.
Okay, I'm fine with that. Let's go ahead and extend the comment period for 15 days. If anyone else wishes to present additional information to us to be filed in this particular ADKT, do so within 15 days. Otherwise, this meeting stands adjourned. The court will stand in recess until.
On the supplemental, I sure would like comment on what Mr. DeJesse said and what I said about a bright line rule. Like to hear what the parties feel about that bright line rule.
Okay, thank you, Justice Cherry. With that, we'll stand in recess until the next call of the court.